Very good evening, all the participants. Today, we are going to discuss a very important section, very important section. Section 208. Because a case study can come on this section alone. Functions and obligations of insolvency professionals. Although these are spread throughout the IBC, but this section is dedicated towards functions and obligations of insolvency professionals. What is required to do, what is expected to do, what is expected not to do. All these things are discussed in section 208. Section 2081, what it says? It says, where any insolvency resolution, fresh start, liquidation, or bankruptcy process has been initiated, it shall be the function of an insolvency professional to take such actions as may be necessary in the following matters, namely, fresh start order process, individual insolvency resolution process, CIRP, pre-packaged insolvency resolution process, individual bankruptcy process, liquidation of a corporate debtor firm, where the name of the insolvency professional proposed to be appointed as a resolution professional is approved under clause E of subsection 2 of section 54A. 54A talks of pre-pack. It shall be the function of such insolvency professional to take such actions as may be necessary to perform his duties, his functions and duties prior to the initiation of prepackaged insolvency resolution process. Because we know in case of prepackaged insolvency resolution process, there are certain duties which an insolvency professional is expected to perform prior to initiation of prepack. That means prior to admission of application. Every insolvency professional shall abide by the following code of conduct. Number 1, to take reasonable care and diligence while performing his duties. Now we will see what is meant by reasonable care and diligence. We will see it through examples. To comply with all requirements and terms and conditions specified in the bylaws of the Insolvency Professional Agency of which he is a member. Because there are certain bylaws of the Insolvency Professional Agency and he has to comply with all requirements and terms and conditions which are specified. To allow the Insolvency Professional Agency to inspect his records. So we saw the provisions relating to inspection and investigation yesterday. And if any insolvency professional agency wants to have a look at his records, he is to allow. To submit a copy of the records of every proceeding before the adjudicating authority to the board as well as to the insolvency professional agency of which he is a member, and to perform his functions in such manner and subject to such conditions as may be specified. So these are the functions and obligations of insolvency professionals. Now there are certain regulations also, because it says to perform his functions in such manner and subject to such conditions as may be specified. So for the information of those who joined late, we are starting with section 208 today. And if time permits, then we'll go to part 5. But section 208 is very important, so I thought of taking up this first. So in brief, we have seen the functions and obligations of an insolvency professional, which are given in section 208. Now these regulations. So now, as we know, there were certain recommendations of Vishwanathan Committee. Vishwanathan Committee was the committee which was chaired by Mr. T.K. Vishwanathan, and it was known as Bankruptcy Law Reforms Committee, BLRC. And there were certain recommendations of, so I'll take you back to the history of this IBC. So there were certain recommendations of Vishwanathan Committee. So this entire insolvency and bankruptcy process is managed by a regulated and licensed professional. So this entire process, this IBC, it is managed by a regulated. Now this professional is regulated. Who is the regulator? IBPI. Is managed by a regulated and licensed professional, namely the insolvency professional or an IP, appointed by the adjudicator. Who is the adjudicator? NCLT or DRT, adjudicating authority. In an insolvency and bankruptcy resolution process driven by the law, there are judicial decisions being taken by the adjudicator. But there are also checks and accounting as well as the conduct of due process that are carried out by the IPs. Insolvency professionals form a crucial pillar. So this is one of the important pillars upon which rests the effective, timely functioning as well as credibility of the entire edifice of the insolvency and bankruptcy resolution process. So it's a very important pillar of the entire process. On the other hand, poor quality services and recurring instances of malpractice and fraud erode consumer trust. In the case of insolvency resolution, a failure of the process may result from two main sources. Now, why this process could fail? Number one, there is collusion between the parties and poor quality of execution of the process itself. Either the process itself is carried out in a poor manner or there is a collusion. So in that case, this insolvency resolution will fail. Hence, it is important that the professionals responsible for implementing the insolvency resolution process adhere to certain minimum standards so as to prevent the failures of the process and enhance credibility of the system as a whole. In India today, there are professionals and intermediaries that offer service to resolve financial stress of both registered entities as well as individuals. Now, these include lawyers, accountants, auditors, valuers, and specialist resolution managers. However, given the critical role that the court envisages for these entities in the resolution process, the committee believes that the board should set minimum standards for the selection of these professionals, along with their licensing, appointment, functioning, and code conduct under the code. To this end, the code empowers the board to lay down the minimum professional standards and the code of conduct to be followed by the IPs at each stage of insolvency and bankruptcy resolution process. So mandates for IPs, which may be prescribed through delegated legislation, are described in box number 4.17. Now, what are the mandates for IPs? An IP will act independently, objectively and with impartiality. An IP will carry out his tasks diligently. An IP will treat the assets of the debtor with honesty and transparency. An IP will avoid all possible conflicts of interest, and if he comes to know of any such conflict, he will disclose the same immediately to the COC. An IP will maintain confidentiality because he is privy to so much information. So an IP will maintain confidentiality of information acquired as a result of professional relationships. An IP will act in a fiduciary capacity towards the debtor and the creditors as a whole when appointed in any capacity in an insolvency and bankruptcy resolution proceeding. An IP will not commit fraud or abuse or exert undue influence on or on behalf of his clients. So this is what is given in the Vishwanathan Committee report regarding the role of IPs. Now, this section 208, which we have already seen, it lays down the functions and obligations of insolvency professionals. So first of all, there is a circular, IBBI circular on this, that which says that, I think we can stop here. So there is a circular which says, what it says? This circular says IBBI circular number IP 0012018 dated 3rd January 2018. So it has been observed that a few insolvency professionals are using different addresses and emails while communicating with the stakeholders. Despite repeated advice from the IBBI to use the addresses and emails registered with the IBBI in all their communications. So it is obligatory on all the insolvency professionals to use the addresses and emails which are registered with the IBBI. There is a circular on that. So it is hereby directed that in all his communications, whether by way of public announcement or otherwise to a stakeholder or to an authority, an insolvency professional shall prominently state his name, address, and email as registered with the IBBI, his registration number as an insolvency professional granted by the IBBI, and the capacity in which he is communicating. For example, an IRP of XYZ Limited, RP of ABC Limited, etc. Additionally, an insolvency professional may use a process, for example, CIRP, liquidation, specific address. So he may use a process specific address also. and email its communications if he considers it necessary, subject to the conditions that the process specific address and email are in addition to the details required in para 2 above. First of all, he will give the name and address and email address as registered with the IBBI. In addition to that, he may use a process specific email also. And the insolvency professional continues to service the process specific address and email for at least 6 months from the conclusion of his role in the process. So there was a case in Sarvesh Kashyap. uh, the IP had accepted the assignment as liquidator after the cutoff date of 31/12/2019 without holding valid AFA. As we know that there was a cutoff date beyond which, unless you are holding a valid authorization for assignment, you cannot continue. But in this case, there was a case in Sarvesh Kashyap. The IP had accepted the assignment as liquidator after the cutoff date of 31/12/2019 without holding a valid AFA. It was held that the IP had contravened the provisions of Regulation 7A of IP regulations and was warned and not to repeat similar action in future. In Manoj Kumar Jain, there is another case. In Manoj Kumar Jain, the professional had given consent on 22nd July, that is prior to the notification relating to AFA. He was appointed as IRP by the adjudicating authority. The professional had also given consent in March 2020 to become resolution professional in the CIRP of another CD without having AFA. The disciplinary committee observed that assignment of IRP and RP were two standalone assignments and held that the professional was not guilty of professional misconduct for accepting assignment of IRP, but imposed a penalty of 10,000 for accepting assignment of RP after 31st December 2020. So there is a penalty provision that in case you do not hold a valid authorization for assignment, you cannot continue as RP or liquidator. In another case, in Ajay Gulati, the IP who had accepted the assignment as IRP prior to threshold date of 31st December in CIRP of corporate debtor without holding a valid AFA was held not guilty of professional misconduct. Then there are other cases also. Now authorization for assignment is necessary. So what comes out of this discussion is that authorization for assignment is necessary. So there is a regulation in terms of regulation 7A. Just a minute. Let me take you to that regulation also. Actually, I am reading from a book, so you may be wondering as to why this screen is not moving. So we are on this regulation, regulation number 7A. In terms of regulation 7A of the IBBI Insolvency Professional Regulations, one of the essential conditions for undertaking any assignment by an IP is that he should have a valid AFA, which is issued by the IPA. So who is issuing this AFA? IPA, with which he is enrolled. Just a minute. हाँ जी संजीव जी, हाँ मीटिंग चल रही है मेरी, एक्चुअली बाद में करते हैं बात। नमस्ते नमस्ते, मेरी मीटिंग चल रही है, बाद में बात करते हैं आराम से। हाँ जी, हेलो, हाँ जी हाँ जी। सर ये ना हाँ जी, तो in terms of Regulation 7A of the IBBI regulations, one of the essential conditions for undertaking any assignment by an IP is that he should have a valid AFA, which is issued by the IPA, with which he is enrolled. In other words, without AFA, an IP is not eligible to undertake any assignments or conduct various processes itself. Regulation 7A was inserted in the IP regulations while notification dated 23rd July 2019, where the IP had given his written consent to COC in its meeting held on 22nd November. Suppose there was a COC meeting which was held on 22nd November and he had given his consent to act as liquidator in terms of section 34 subsection 4, and accordingly the same was filed with the NCLT on 28th November 2019 prior to the requirement of AFA for accepting or undertaking assignment under Regulation 7A, which came into effect from 1st January 2020, because this came into effect on 1st of January 2020. Suppose a person had given his consent to act as liquidator prior to this date, that is before So this requirement amounts to outsourcing responsibilities of an insolvency professional to another person. Further, this adds to cost. Just a minute. The disciplinary committee took note that an IP who was more than 70 years of age could not make an application for the grant of AFA. As we know, you cannot make an application for authorization for assignment if you are more than 70 years. Since the IP was aged 78 years old, in this case, IP was aged 78 years old, he could not apply for obtaining grant of AFA and hence could not hold AFA. In the aforesaid backdrop, especially in the context of age bar and also the written consent being filed by the IP with the NCLT on 28th November, prior to the coming into effect of the requirement of AFA, the DC did not find any lapse on the part of the IP. So basically the cutoff date is 31st December 2019. So after that, if you give any consent without holding a valid authorization for assignment, then you may be in trouble. But all these cases were prior to that date. The cutoff date for AFA is 31st December 2019. Now, violation of regulations and code of conduct. The RP is to make an independent determination on the avoidance transactions. Regarding avoidance transactions, we all know that there are 4 types of transactions: PUFE transactions, preferential, undervalued, fraudulent, and extortionate. Now, who is to make an independent determination? It is the RP or the liquidator. The RP is to make an independent determination on the avoidance transactions, and then he shall apply to the adjudicating authority for appropriate relief. And there are timelines also, like 75, 115, and now 130. I think now it is 130. Earlier it was 135th day. Am I correct?
Yes, sir.
Yes, sir. Yes. So, transactions through progress reports. Now, in this case, what happened? Where the RP, after finding the avoidance transactions, merely intimated the AA about such transactions through progress reports. Because we know, although during CIRP, there is no such requirement of the code to uh, give quarterly reports, but whenever there is a COC meeting, normally the practice is that as soon as any COC meeting is held, the RP informs the adjudicating authority through a progress report. Now, in this case, he was keeping the adjudicating authority in loop through various progress reports, but he did not file any such determination or forming of opinion because there are timelines like 75, 115, and 130. So in this case, what he did, he, RP, after finding the avoidance transactions, merely intimated the A about such transactions through progress reports, but did not file application before the adjudicating authority under section 43(1) of the IBC. It was held that though he was not aware of court procedures, the RP should have been more diligent to recover the amount instead of whiling away 180 days of the CIRP period. This is so as the IBC envisages a time-bound process to ensure maximization of the value of assets for the interest of all the stakeholders. And it was the duty of the RP to initiate forensic audit, make a determination on the avoidance transactions, and file an application before the adjudicating authority to reverse the transaction instead of awaiting the orders of AA based on the submission of progress reports and without taking any follow-up actions. Basically, he has to act in a proactive manner. He cannot say that I have informed the adjudicating authority and based on the adjudicating authority, I will decide, I will do whatever they, because it is your primary duty as an RP to form an opinion, to determine and to file for these PUFE transactions. So hence, his conduct was found to be in explicit contravention of section 25(2)J, 43(1)(208) and also regulation 35A of CIRP regulations. Okay. So now we are seeing it. What are the duties of RP and where he is found lacking? One could be this authorization for assignment. If he takes up an assignment without holding valid AFA, particularly after 31st December 2019. Second is if he violates the regulations or code of conduct. Suppose he is duty bound to make an independent determination on the avoidance transactions and he simply informs the adjudicating authority through the progress report, but he doesn't take any action on his own. So then also he could be in trouble. Next is RP to update knowledge to render professional service. He is expected to be an updated person. The RP steps into the shoes of the board of directors because the powers of the board stand suspended. Now he is all in all. He cannot say that I don't know this thing or that thing. He is expected to be omniscient. The RP steps into the shoes of the board of directors of the distressed CD and plays a crucial role in bringing resolution to the failing CD. It is the responsibility of the RP to take major decisions on the day-to-day functioning of the CD and to safeguard the interests of the stakeholders. The RP cannot claim that he was not aware of code procedure, as it is the duty of RP to update his knowledge and skills to render competent professional service. He can also appoint a legal professional because he cannot have all the knowledge, but he can appoint professionals. But ultimately, the responsibility is his or seek advice from legal professionals. So there was a case, Balaknath Bhattacharya. Disciplinary action was taken against IP for undertaking assignment without a valid AFA. Since the IP was more than 70 years of age and thus ineligible to apply for AFA, show cause notice issued against him was to be disposed of without any direction against him. Now, instances of professional misconduct. Now, we will see the instances of various professional misconduct. The IP had given consent to accept the assignment as IRP in Form 2 on 12th April 2019 in the CIRP of the CD, and the date of commencement of the CIRP was 3rd December 2019. However, he was ratified as RP on 6th January 2020. That is after the threshold date of 31st December, because for AFA, the threshold date is 31st December. The DC was of the view, DC means disciplinary committee, that though acceptance of assignment was prior to cutoff date, the insolvency professional should have applied for AFA, especially in view of ratification of his name to act as RP by the COC. Since the insolvency professional had accepted assignment as RP after 31st December without holding a valid AFA, he was found guilty of professional misconduct and a penalty of 10,000 was imposed. And there are so many other cases on this AFA. So without an AFA, IP is not eligible to undertake assignments or conduct various processes thereof, as it is an essential condition for undertaking any assignment. Next is insolvency professional to ensure compliance with applicable laws. So he should be aware about the various laws. There is a circular on this. IBBA circular number IP oblique 002 oblique 2018 dated 3rd January 2019. And all these circulars, they are also in our syllabus. And we are expected to read all these circulars, guidelines. A corporate person undergoing insolvency resolution process, fast track, liquidation or voluntary liquidation needs to comply with the provisions of applicable laws, acts, rules, regulations, circulars, guidelines, orders, directions during such process. For example, a corporate person undergoing IRP, if listed on a stock exchange, needs to comply with every provision of the SEBI LODR regulations, unless the provision is specifically exempted by the competent authority or becomes inapplicable by operation of law for the corporate person. Suppose you are dealing with a listed company. So in that case, you are expected to know about the LODR obligations. You are expected to be conversant with the various laws in relation to the company whose CIRP or liquidation you are handling. It is hereby directed that while acting as IRP, a resolution professional or liquidator, an insolvency professional shall exercise reasonable care and diligence and take all necessary steps to ensure that the corporate person undergoing any process under the code complies with the applicable laws. It is clarified that if a corporate person during any of the aforesaid processes suffers any loss, including penalty, if any, on account of non-compliance. Now, who will bear the penalty in case there is any non-compliance? Such a loss shall not form part of insolvency resolution process cost or liquidation cost. It is also clarified that the insolvency professional will be responsible for the non-compliance of the provisions of the applicable laws if it is on account of his conduct. So, if there is any penalty which is levied on account of his lack of knowledge of the applicable laws, then RP will bear the loss, not the company. It will not become part of the insolvency resolution process cost. Then complaints against IP. IBBI to inform complainant formation of its prima facie opinion. The petitioner filed complaint before the IBBI against the IP. under the IBBI grievance and complaint handling procedure. So we saw yesterday this grievance and complaint handling procedures that anybody could file a complaint against any of the service providers, and IP is also a service provider. The Delhi High Court was of the view that the complainant had to be informed as to whether the IBBI had formed a prima facie opinion in favor of the complainant or against it. Okay. Next point is that insolvency professional is not to outsource his responsibilities, because the liabilities is, and there is a circular on it. IBBI circular number IP oblique 003 oblique 2018 dated 31st, dated 3rd January 2018. The IBC, read with regulations made thereunder, cast specific duties and responsibilities of on an IP. An IP is required to perform certain tasks under the code while acting as IRP, RP, liquidator, or bankruptcy trustee. For example, an insolvency professional is required to manage the operations of the corporate debtor as a going concern. He is also required to invite resolution plans, examine them, and present them to the COC for its approval. Such a resolution plan which complies with the provisions of the code. To assist him in carrying out his responsibilities, they allow an insolvency professional to appoint accountants, legal, or other professionals. So he is very well within his power to appoint accountants, legal, but the responsibility will not be outsourced. It has been observed that a few insolvency professionals are advising the prospective resolution applicants to submit a certificate from another person to the effect that they are eligible to be resolution applicants. Now, whose responsibility it is to see that whether the person who is submitting the resolution plan is eligible or not? It cannot be done merely by way of a certificate. Suppose you are an RP and you are handling the CIRP of a particular company. A resolution applicant come and you ask him that, okay, you get a certificate from another insolvency professional that you are eligible. No, the responsibility is not complete. This requirement amounts to outsourcing responsibilities, because you as an insolvency professional, you as a RP is required to check whether that particular resolution applicant is eligible or not under 29A. This requirement amounts to outsourcing responsibilities of an insolvency professional to another person. In this case, what happened was that this was the case of a company where it was said that, okay, a certificate from a chartered accountant, a certificate from another insolvency professional that you are eligible. Further, this adds to cost of the resolution applicant. Otherwise, and delays submission of resolution plans. The code read with regulations do not envisage such a certificate from a third person. So there is no need of certification from a third person. You are an RP, you check yourself. It is hereby directed that an insolvency professional shall not outsource any of his duties and responsibilities under the code. He shall not require any certificate from another person certifying eligibility of a resolution applicant. Next is incorporation of partnership firm with IBBI as part of name. So in this case, what happened was the RP had used named IBBI Insolvency Practitioners LLP. So he used this name. So in a way, he is saying that he is somewhere attached with IBBI. So you cannot keep any such name, IBBI Insolvency Practitioners LLP. Considering that the RP had used name IBBI in firm's name, a show cause notice was issued to the RP. IBBI disciplinary committee observed that RP's conduct was in violation of section 208. Okay. So in this case, they suspended the period of suspension. The court held that since the name of the partnership firm incorporated by the RP had already been struck off from the register of companies and period of suspension of 3 months had already passed, the court could not interfere. So in this case, his registration was suspended for 3 months and this name was struck off. Unreasonable costs spent by the resolution professional, because now you are in charge of funds. So if you do some unreasonable costs, if you spend the money unreasonably, then what will happen? So clause 7 of the code of conduct cautioned the resolution professional that the costs spent at RP's instances payable to any professional on account of resolution costs shall not be unreasonable. Suppose you appoint a valuer, suppose you appoint a legal professional, then you cannot pay unreasonable remuneration. So you have to be reasonable. So clause 7 of the code of conduct cautioned the a resolution professional that the costs spent at RP instances payable to any professional on account of resolution cost shall not be unreasonable. The cost must be on the basis of the volume of work and complexity of the resolution process. Mostly all works outsourced to a firm in which the RP admittedly a partner and thereby violated the circular issued. Truly, all the costs the RP spent out of the resolution process must be ratified by the COC. And in this case, the COC seen responsible for fixing or rather approving the cost which is at an unreasonable rate. No doubt it gives an additional financial burden to a sinking company which is under a resolution. Show cause notice was issued to IP, appointed as RP in the CIRP of three companies, alleging wrongful inclusion of legal cost in insolvency resolution process cost. So suppose you are an RP and sometimes what happens is your financial creditors, they seek some legal opinion. So the question here is whether you can include that cost of that legal counsel, which is giving opinion to the financial creditors as part of insolvency resolution process cost. The answer is no. So in this case, show cause notice was given to insolvency professional appointed as RP in the CIRP of three companies alleging wrongful inclusion of legal cost in insolvency resolution process. Since the contraventions pertain to the period prior to issuance of the circular, the notice was disposed of without any direction to IP. The IRP outsourced its primary duty in engaging an independent professional for verification of claims and also included costs incurred in verification of claims separately in CIRP costs. Because whose duty it is to verify the claims? It is the duty of the RP or IRP. So in this case, the IRP outsourced its primary duty in engaging an independent professional for verification of claims and also included costs incurred in verification of claims separately in CIRP costs. It was held that this is in contravention of section 18(1)(g) and section 208. So penalty equal to fees paid to independent professional was to be imposed on the IRP. So if you want verification of claims, you can get it done, but it is included in your fees because it is your duty to verify the claims. You cannot say that, okay, I have engaged such and such person for verification of claims and I am paying him so much amount. So in this case, penalty equivalent to the fees paid to the independent professional was to be imposed on the IRP. Now, costs towards non-essential activities disallowed. Suppose you incur some non-essential activities, then what will happen? The continuation of the CIRP process by the IRP after filing of an application for settlement under section 12A before NCLT, well before constitution of the COC, without making adequate efforts to seek pointed clarification from the adjudicating authority or whether to proceed with the CIRP or not, would not reflect well on his conduct. Suppose you have been appointed as IRP. Now there is a section 12A application. Section 12A, you know, it is withdrawal application. And after that also, suppose you continue with activities, then what will happen? So this is a case on those lines. It would not reflect well on his conduct. It has been held that the IRP cannot afford to be unmindful of the fact that he is the driving force and the nerve center in the resolution process and is expected to assist in the CIRP process in a fair and objective manner in the best interest of all stakeholders. Simply by registering presence on each date of hearing before the adjudicating authority without seeking clear guidance on the CIRP modalities could not in itself become a sufficient ground for the IRP to proceed with the CIRP full throttle. As an officer of the court, it was incumbent upon the IRP to highlight before the adjudicating authority the special and peculiar circumstances that he was confronted with in the matter. Instead of pursuing the withdrawal application with greater vigor, he has rather chosen to mechanically proceed with CIRP by taking the plea of adherence to CIRP regulations. So you cannot be unmindful of the fact that withdrawal application has already been submitted and you are just carrying on your meter. The conclusion of the adjudicating authority that the conduct of the IRP, though may be technically correct, the same cannot be countenanced given the attendant circumstance was held to be proper. Further, that since the IRP seemed to have taken advantage of the fluid situation and unnecessarily added to the costs by carrying out activities which could have otherwise been put on hold. The adjudicating authority had correctly disallowed costs towards non-essential activities. So, if you incur any cost towards any non-essential activities which you are not expected, although you may be technically correct, but in that case, they will disallow such costs. Now, fees payable to an insolvency professional and to other professionals. So there is a circular on that, circular number 4. What it says, section 206 of the IBC provides that only a person registered as an insolvency professional with IBBI can render services. Okay? This code requires that an insolvency professional who is appointed as an IRP or RP shall conduct the entire CIRP, including fast track. In terms of section 5 subsection 13, the fees payable to any person acting as a resolution professional is included in the insolvency resolution process cost, which needs to be paid in priority. The code of conduct for insolvency professionals under the IBBI IP regulation requires that an insolvency professional must provide services for remuneration which is charged in a transparent manner and is a reasonable reflection of the work necessarily and properly undertaken. He shall not accept any fees or charges other than those which are disclosed to and approved by the person fixing his remuneration. In view of the above, it is clarified that an IP shall render services for a fees which is a reasonable reflection of his work, raise bills invoices in his name towards such fees, and such fees shall be paid to his bank account. Any payment of fees for the services of an insolvency professional to any person other than the insolvency professional shall not form part of the insolvency resolution process. Similarly, any other professional appointed by an IP shall raise bills invoices in its such as registered value name towards such fees, and such fees shall be paid in his account directly. Okay. The above circular clarifies that an insolvency professional shall render services for a fees which is a reasonable reflection of his work, raise bills invoices in his name towards such fees, and such fees shall be paid to his bank account. So where the IP in respect of our role as a liquidator in the matter of voluntary liquidation of 6 corporate persons did not raise invoice for work in her name, but in the name of her firm. So what she did in this particular case, she raised the invoice in the name of her firm, although she was appointed by name. Even when the circular was issued, a show cause notice was issued to the IP alleging contravention of section 208. It was found that IP was negligent as she did not take reasonable care and due diligence, and there was non-compliance of the circular by her. And it was not only in one matter, but it continued in all 6 matters. So if you are an insolvency professional, you are running a partnership firm, so you have to raise the bill in your own name because your appointment is by name and not in the name of the firm. The IP was directed to undergo pre-registration educational course from the IPA of which she was a member and to pay penalty equal to 10% of the fees she had received in 6 assignments. So sometimes they ask you to again undergo this pre-registration educational course. Sometimes they levy penalty also, and sometimes they terminate the license also. And further that she shall not accept any new assignment as an IP till she deposited penalty amount with the IBPI and completed pre-registration educational course. Now, disclosure by insolvency professionals and other professionals. There is another circular, circular number 5. What it says, so you are expected to study all these circulars. The Insolvency and Bankruptcy Code, read with regulations made thereunder, provide for appointment of an insolvency professional to conduct the resolution process, CIRP, fast track, etc. These authorize the insolvency professional to appoint registered valuers, accountants, legal and other professionals. In the interest of transparency, it has been decided that an insolvency professional and every other professional shall make disclosures as specified in para 3 to 5 hereunder. So there are paras in the circular that they will make disclosures. An insolvency professional shall disclose his relationship. Suppose you are an IP and you are related to the corporate debtor, you are related to other professionals engaged by you, financial creditors, interim finance providers, and prospective resolution applicants. To the insolvency professional agency of which he is a member, within the time as specified in this circular. So there could be certain situations where you are related to either of the parties involved. You are related with ECD, you are related with other professionals, you are related with financial creditors, interim finance providers, prospective resolution applicants. So in all these cases, there is a mandate that you are required to disclose this relationship to the IPA of which you are a member, and there is a time limit for that. Now, there could be another point, inclusion of EOI after last date. Yes, you know, expression of interest is issued for seeking resolution plans. So, if there is an inclusion of EOI after the last date, then what will happen? So, in this case, the disciplinary committee of IBBI found that the IRP or RP, by inclusion of an expression of interest after the last date, had contravened regulation 36A of the CIRP regulations, because you cannot entertain any EOI after last date. It was also found that IP had contravened Section 208 and did not take reasonable care while making disclosures. So, insolvency professional was directed not to seek or accept any process or assignment or render any services for a period of 12 months. Now, fees and other expenses incurred for CIRP. So, there is sometimes a problem on the fees part also, because nothing is clearly given as to how much fees he can charge, but it should be a reasonable reflection of the work. So there is a circular on this, okay, where when a CD undergoes CIRP, an insolvency professional is vested with the management of its affairs, and he manages its operations as a going concern. He complies with the applicable laws on behalf of the CD. He conducts the entire CIRP. So such responsibilities of an IP require the highest level of professional excellence, dexterity, and integrity. He needs to be compensated for his professional services commensurate to his ability, duties, and responsibilities. He also needs to pay fees or incur other expenses for various goods and services required for conducting the CIRP and or managing the operations of the corporate data as a going concern. So the IP is directed to ensure that the fees payable to him, fees payable to the IPE, fees payable to the registered valuer and other professionals are reasonable. Fees or other expenses incurred by him are directly related to and necessary for the CIRP. Fees or other expenses are determined by him on an arm's length basis. Written contemporaneous records for incurring or agreeing to incur any fees or other expenses are maintained. So there should be complete transparency regarding the fees which he is charging and which is paying to other professionals. Then supporting records of fees and other expenses incurred are maintained at least for 3 years from the completion of the CIRP. Then approval of the COC for the fees and other expenses is obtained. So this is regarding fees. Now, professional fees to depend on expertise and cannot be denied or reduced. The liquidator of corporate debtor, who was also asked while IRP of same corporate debtor, filed an application seeking directions with regard to payment of dues of CIRP period. The adjudicating authority observed that he had performed duty of IRP and constituted COC and thereafter continued to function even beyond 30 days till date of liquidation of corporate debtor by respondents. The applicant was held entitled to get fees and costs incurred. Replying on the aforementioned circular, it had been contended that considering the availability of other insolvency professionals at lower rate, the creditors should not be saddled with high fees payable to the applicant. The adjudicating authority was of the view that the availability of other professionals at lower rate did not warrant for reduction in fees remuneration of the insolvency professional, as COC members, apart from exercising their commercial wisdom, should consider that every insolvency professional has his or her own experience, skill, expertise, volatility, independence, which were also of prime consideration. So it is not that suppose insolvency professionals are available at lower cost, so you deny the person is because every person may charge differently. So in this case, the matter went in favor of the liquidator. Then duties and liabilities of insolvency professionals. Insolvency professional owes duties to company. So first of all, duties to the company. because he is responsible for all the compliances. And administrator of the insurance company was appointed to manage the business affairs of the company and for realizing the assets of the company. The administrator sold the company's business as according to the administrator, the company was not in a financial state to borrow money for trading. So in this case, an administrator of the insurance company was there. He was appointed to manage the business affairs of the company and for realizing the assets of the company. The administrator sold the company's business. As according to the administrator, the company was not in a financial state to borrow money for trading. The creditors petitioned against the administrator as the administrator failed to take reasonable care to obtain proper price of the company's business. The Chancery Division Companies Court held that the administrator owed duty of care to the company. However, on the facts that the petitioner failed to establish any loss or the negligent act of the administrator, it was common ground that the administrator owes the duties to a company over which he is appointed to take reasonable steps to obtain a price for the assets. This is an obligation which the law imposes on anyone with a power. An administrator, by contrast, like a liquidator, has no interest of his own to which he may give priority and must take reasonable care in choosing the time at which to sell the property. He is not to be made liable because his perception is wrong, unless it is unreasonable. An administrator must be a professional insolvency practitioner. A complaint that he has failed to take reasonable care in the sale of the company's assets is therefore a complaint of professional negligence. And in my judgment, the established principles applicable in case of professional negligence are equally applicable in such a case. It follows that the administrator is to be judged not by the standards of the most meticulous and conscientious member of his profession, but by those of an ordinary skilled practitioner. In order to succeed, the claimant must establish that the administrator has made an error which a reasonably skilled and careful insolvency professional would not have made. Now, insolvency professionals' duties to creditors. I think we can take a break of 5 minutes and then we can resume. ठीक है जी, आज थ्योरी थ्योरी ज्यादा हो गया तो थोड़ा सा लेट अस टेक अ ब्रेक ऑफ 5 minutes. So now let us see some of the insolvency professionals' duties to creditor. So there is a case law in this. The liquidator, while performing its function, simply omitted a potential claim of a creditor because liquidator is required to include all the claims. Suppose you omit a particular claim. He simply omitted a potential claim of a creditor. Further, the liquidator failed to inform the creditor about the liquidation. So in this case, it was held that a more gross dereliction of duty by liquidator I have seldom heard of. The question now arises whether he is under any liability to the plaintiffs who sue in respect of debts of the old company. It certainly would be somewhat shocking if there was no remedy in such a case as this, and I'm glad to have been able to persuade myself that there is a cause of action against the liquidator. So, liquidator was held responsible for omitting a potential claim of a creditor, and he failed to inform the creditor about the liquidation. So, this aforesaid decision was approved in James Smith and Sons, wherein the liquidator made errors in paying out. So because you as a liquidator are required to pay out to the stakeholders. So if you make an error in that, then what will happen? The result is that the liquidator, acting no doubt in complete good faith, but still in breach of his duties, committed a breach of the duty laid on him to pay the debts of the company. The case is exactly within the decision of Farwell. So if you do not distribute as per section 53, then you may be in trouble. Liquidator owes direct duty to creditors. The creditors of the company which went into liquidation entered into a contract with the accountant firm. As per the agreement, the creditors will support the appointment of an employee of the firm as liquidator of the company, with a view to investigate the conduct of the directors and ascertain whether proceedings can be taken against directors. Subsequently, the creditors alleged breach of the contract and duty of care as they delayed to inform the creditors about the status of investigation, and for such a long time that the claims became barred by statute. Then general duty to protect creditors' collective interests. we see something important: existence, content, and engagement of creditor duty. Creditor duty at common law, application of creditor duty on decision of directors, directors when to consider creditors' interests, duties of insolvency professional and code of conduct. First is independence and impartiality. IP should maintain complete independence in his or her professional relationship and should conduct the insolvency resolution, liquidation, or bankruptcy process. And he should not do the following. Just a minute. So the first duty is independence and impartiality. So he should maintain complete independence in his or her professional relationship and should conduct the insolvency resolution process, liquidation or bankruptcy independent of external influences. So he should not do the following. Knowingly, he should not acquire the assets of the debtor with which he is dealing during liquidation or bankruptcy process, and also ensure that his or her relatives do not acquire any such assets. Okay? Suppose you are handling a, say, builder, and the builder has got a flat and you are interested in buying that flat, you should avoid such things because there is a conflict of interest. He should not knowingly acquire any assets of a debtor with which he is dealing during liquidation or bankruptcy process, and also ensure that his or her relatives do not acquire any such assets, whether directly or indirectly, unless it is shown that there is no impairment of objectivity, independence, or impartiality in the liquidation or bankruptcy process and the approval of IBBI has been obtained in the matter. So either you prove impartiality, you obtain approval of IBBI, otherwise you better stay away. Take up an assignment under the code if he or his relatives or any of the partners or directors of the is a partner or director. Suppose you should not take any such assignment under the code if he, she, or any of his or her relatives or any of the partners or directors of the insolvency professional entity of which he is a partner or director, or the IP of which he is a partner or director, is not independent. Okay? In relation to the corporate person or debtor and its related parties. You should not accept any assignment unless you hold valid AFA. You should disclose the existence of any pecuniary or personal relationship, okay, with any of the stakeholders. You should disclose as to whether he was an employee of his, of, or has been in the panel of any financial creditor of the corporate debtor, to the committee of creditors and to the insolvency professional agency of which he is a professional member, and ensure that the agency publishes such disclosure on its website. So all these things you should disclose. Then you should not influence the decision or the work of the committee of creditors or debtors or other stakeholders under the code so as to make any undue or unlawful gain for his or her or for his or her related parties, or cause undue preference for any other persons for undue or unlawful gains. Then professional competence and confidentiality. So you can go through all these things. These are our regulations. Now, professional competence and confidentiality. IP must continuously try to maintain and upgrade his professional knowledge and skills. Maintain at all times confidentiality of the information. IP should disclose any information if necessary with the consent of the related parties. Should not also use confidential information acquired as a result of professional or business relationship for the personal advantage of yourself or other parties. Then representation of correct facts and correcting misapprehension. Then timeliness prescribed. Issue related to the timelines. Information management. So because he is required to connect with the various stakeholders. So IP must make efforts to ensure that all communication to the stakeholders, whether in the form of notices, reports, updates, directions, or clarifications, is made well in advance and in a manner which is simple, clear, and easily understood by the recipients. Maintain written contemporaneous records for any decision taken, the reasons for taking the decision, and the information and evidence in support of such decision. This shall be maintained so as to sufficiently enable a reasonable person to take a view on the appropriateness of your decision. So information should be clear. IP must appear, cooperate, and be available for inspection and investigation, etc. Then occupation, employability, and restrictions. Hmm. So IP should refrain from accepting too many assignments. IP should not engage in any employment when he is having a valid authorization for assignment or when you are undertaking any assignment. You should not accept any employment when conducting a CIRP. Engage or appoint any of his relatives for or in connection with any work relating to any of your assignment. Then remuneration and costs. So cost remuneration should be charged in a transparent manner and it should be a reasonable reflection. You should not accept gifts. Hmm. Then threats for compliance with fundamental principles. So I think we have seen sufficiently the roles and liabilities of the insolvency professional. So along with this, what I will recommend is that let me share another PPT with you. Hmm. So I hope this PPT is visible to you now. So we have covered in this 208. These are the regulations we have already covered. And after this regulation, what we have done is, so I've included this point of independent director because if you are not able to be appointed as an independent director, then you cannot be appointed as a resolution professional. So I've reproduced here what is meant by an independent director from the Companies Act. So you can go through all these things. And these are the various situations which I have tried to discuss. So you can go through all these and we can discuss in the group if anything uh, is not understandable. So you can go through this material and we have already covered some of the issues here. So these are the various issues on which IBBI may grill you and these are some of the disciplinary cases. Basically, this is a gist of the disciplinary cases. So you please go through this. I'll share this PPT with you. This is a red flag document of IBBI. You can go through. This is all reference material. You go through to the extent you feel appropriate. These are some of the questions also. So I'll share all this with you, and I think we can stop here and we can invite if there are any questions. So tomorrow we'll